In today's topic, we will be covering Lesson 2.2, Offer and Acceptance, found in our business law textbook. The goals are to explain how to create a valid offer, describe the various ways an offer can be terminated before acceptance, and recognize the importance of acceptance and consideration to contract formation. An offer is a proposal of a bargain or exchange to another party or parties. If the offeree accepts the proposal, a contract arises. Generally, to create a valid offer, the following must occur. 1. The offerer must intend to create a legal obligation as judged from the standpoint of a reasonable observer. 2. The terms must be complete and definite. 3. The offer must be communicated to the offeree. The law will only recognize that an offer exists when the offerer seemingly intends to create a legal obligation from the standpoint of a reasonable observer. Test of the reasonable observer. When the law must determine if the offerer intended to make the offer in question, the focus is not on what was actually in the mind of the person making the offer. Rather, it is concerned with how the alleged offerer's actions would be interpreted by a reasonable observer. If you are joking when you offer your neighbor twice the value of a car she has for sale, but a reasonable person would interpret your conduct as an indication that you intend to contract, the law will hold that you have actually made such an offer. On the other hand, if you are serious, but a reasonable person would interpret your conduct as a joke, then no offer has been made from a legal standpoint. This is called the test of the reasonable person. It is an objective legal test, rather than a subjective test based on what you say you were thinking. Businesses and the law need a consistent way to determine when an offer is made. A subjective test would let people escape contractual responsibilities by lying about what they were thinking. Note that some agreements are unenforceable, even if a reasonable person would conclude that they were made. For example, social agreements such as dates do not produce legally enforceable contracts. In the case of Bill and Michael, the courts could not be used to force either party to fulfill the agreement, to go to the movie, or to pay damages for harm caused by not doing so. Most advertisements in newspapers and magazines, on radio or television, or in direct mailings usually are not offers. Instead, courts treat them as invitations to make offers. This allows the would-be seller to test the market and adjust the price accordingly. If you placed a classified ad in the newspaper to sell your riding lawnmower for $350, and 10 people promptly called and said they were driving over with cash in their hands, you would probably adjust the price upward. The law allows this. Even so, advertisements occasionally may be offers. For example, an ad may become an offer if it asks the offeree to perform an act as a way of accepting. An ad that states that a clearly described new 160-piece tool set will be sold for $20 to the first person to appear at the front door of our hardware store on Saturday morning after 6 a.m. would be a valid offer. Offers must be complete. If an offer is missing essential information, it is incomplete and legally ineffective. Nearly all offers must identify the price, subject matter, and quantity, either directly or indirectly. The amount of essential information to include depends upon the complexity of the transaction. Offer must be definite. Each essential term must be identified clearly in order for the courts to enforce an agreement. In some contracts, however, a term might be implied by law or common business practice. Offer must be communicated to the offeree. A person who is not the intended offeree cannot accept the offer. Nor can a person accept an offer without knowing it has been made. Possible termination of the offer before acceptance. Revocation. Generally, any time before an offer has been accepted by the offeree, the offerer may withdraw or revoke it. This revocation must be communicated to the offeree to be effective expiration of a set period, or a reasonable time. Rejection by the offeree. An offer clearly rejected by the offeree is terminated. Counteroffers. Other circumstances, death, or insanity of either the offerer or the offeree before acceptance terminates the offer. The destruction of the specific subject matter also terminates an offer. An acceptance is the agreement by an offeree to the terms of the offer. Consideration is what the offerer demands, and generally must receive, in order to make the offer legally enforceable. 1. It must at least entail the making of a promise, performance of an act, or a forbearance from acting. 2. Each party's consideration must be in exchange for consideration given by the other party. 3. What each party exchanges must have legal value. That is, it must be worth something in the eyes of the law.